There we go. Hello, everyone. Welcome to our concurrent panel 8 on Jura, Novit, Arbiter, Presumptive, Peril, or Potential, a fascinating issue in the area of international commercial arbitration and international investment arbitration. So it's great to see so many of my students in the audience. I'm Jason Yaki. I'm a professor of law at UW here, and I research investment treaty arbitration, and I teach international commercial arbitration, although we never discussed the issue of this panel. And so I'm thrilled to learn more about it today. The issue is, and something that Mohammed will speak more on in just a minute, is the presumption that arbitrators know the law. And I guess we can suppose that at least in some cases they do, but others they do not. And we'll talk about how the law handles that presumption. If you're not muted, could you please mute? I hear some feedback. So I'll just briefly introduce the speakers before diving into our roundtable discussion, which will proceed through what we envision as a guided question and answer Q&A format. And so I'll ask the panelists a set of questions, and we'll try to construct a dialogue around the responses. We've had one unfortunate snafu. I think there was some confusion about the start time of the panel, and so we're still trying to get our host, Xian Bao, online. And so she's not here right now. We will adapt and hope that she joins us soon. I'll introduce her anyway, even though she's not here, because she's one of our star graduates from the University of Wisconsin Law School, and a proud Badger. That's our mascot here. Xian previously administered the Hong Kong International Arbitration Center, and now she's a highly in-demand arbitrator based in Singapore. And she's also an honorary senior fellow at BICL, the British Institute of International and Comparative Law. I'm thrilled to have with us as well three very experienced and distinguished international arbitrators. And so first we have Dr. Mohammed Abdel Wahib. He's a professor of private international law and international commercial arbitration at Cairo University. He has an extensive arbitration practice and has served by his count in one capacity or another on well over 200 disputes. I think the count was 235 maybe. And they involved virtually all of the world's leading arbitration centers. It's truly an impressive record. We have Dr. Friedrich Rosenfeld, who's a partner in the Hamburg law firm of Hainfield. He's served as an arbitrator in numerous domestic and international arbitrations, and most recently has served as a global professor of law and practice at New York University's School of Law in Paris. And finally, we have Dr. Michel Podesta, who's a partner in the firm of Levy Kaufman Kohler, which I think I'd view as one of the world's leading boutique firms specializing in investor state arbitration. And so he's participated in dozens of major international arbitrations, and he's a member of the faculty of the Geneva LLM program in international dispute settlement, a very prominent and prestigious master's degree program. And so to start off, pending Xian's arrival, I'd like to ask Mohammed to briefly introduce the topic and to give us just a brief overview of the issues that it presents before we dive into the questions.
Thank you very much, Jason. It's a pleasure to join you today, and it's a pleasure definitely to be alongside my colleagues Michele and Frederick, and hopefully Xian will join us shortly, addressing this very topical issue. And I must say, something not really for the faint-hearted. It is deeply rooted in the very essence of how decision makers approach issues in dispute. To give people some context, in case this is new to them, Jura Novit Curia or Jura Novit Arbiter basically deals with the Aristotelian concept, which addressed by Aristotle on rhetorics. The court knows the law, or at least is expected to know the law. And here a number of issues arise. When we talk about the court or the arbitral tribunal knowing the law, do we mean that they apply the law sua sponte, on their own initiative, or once it is pleaded by the parties? And what happens if certain legal issues are not pleaded by the parties? Should the court or the arbitral tribunal intervene during the proceedings or at the time of making the award to put things in a right context by addressing these legal questions? The issue also ties in to certain aspects where jurisdictions across the globe differ in dealing with this matter. So there are diverse backgrounds, cultural backgrounds of decision makers, adjudicators at the international level or at a national level to decide how best to approach ascertaining the content of the applicable law. Now, we all know that issues in dispute relates to fact and law. And normally the facts are given by the parties, and the principle known in many jurisdictions is basically give me the facts, I give you the law. And to that extent, jurisdictions may vary in terms of how they approach the issue of the applicable law, especially if it's a foreign law. And this relates, people who are familiar with private international law, relates to a concept of the procedural treatment of foreign law. The situation, of course, is compounded in international arbitration because arbitrators do not render justice in the name of a certain state. So there is no lex fori per se in that sense. Arbitrators apply the law agreed by the parties or the law determined in accordance with the applicable procedural rules decided in that sense. And so are arbitrators expected to know the law of all countries in the world? How should that be established before the arbitral tribunal? Is the procedural treatment of foreign law a matter of law or fact? All these matters arbitrators grapple with, in a sense. And it's even more complicated as well in investment arbitration. And I know my colleagues will address you on that. But some adjudicators and in international investment arbitration, arbitrators, some of them with a different background, different education, perception of approaching Jura, Novit, Arbiter, feel that they are guardians of international law, and being a guardian of the law requires you to apply it correctly. So I think today we're in, hopefully, for a treat to address the difficult questions dealing with how should arbitrators approach the question of ascertaining the content of the applicable law. Do the adversarial nature or the inquisitorial nature of the proceedings or the background of the arbitrators play considerable role in their understanding and approach and perception to how they apply that concept? Or is it something that can lend itself to a uniform rule or indeed a harmonized one internationally? Is that desirable, to have a uniform rule that applies in different jurisdictions, even when they pertain to different legal families, in arbitrations, whether commercial or investment? Or does that in itself brings about its own risks and challenges that arbitrators have to deal with? I think these are all pertinent issues that we will address, of course, in due course. I just invite my colleagues, whether Michele or Frederick wished at that point in time to add anything in relation to this introductory remarks, or whether we should move forward with the roundtable discussion that we had contemplated.
I think you have very well set out the scene, Mohammed. So I think it would make sense, from my point of view at least, to proceed with a roundtable.
And I fully agree with this. Yeah, this was excellent introduction. Thank you so much, Mohammed.
Thank you very much, Mohammed, for doing that. Given the unexpected absence of of Shian, so I've emailed her again on a different email. So hopefully she will get it. Is one of the challenges with a global Zoom conference, I think, is managing all of the time zones and different schedules. So we have a whole list of things that we can talk about. I mean, starting at really the most basic level, I was wondering if you guys wanted to dive into the one of the more general questions, but I think also one of the more important ones, which is party expectations. And so, what do parties expect as to knowledge of the law, and is that even the right way to think about the issue or question? In other words, when we ask whether parties expect the arbitrators or the judges to know the law, Are we asking the same thing as whether arbitrators should be presumed to know the law in the sense of, or for the rather different purposes of Jura, Novit, Curia? And so I guess first, if I can just simplify, how do parties, what knowledge do parties have of this issue coming in is one aspect of the question. The other is, to what extent do they expect arbitrators to already know the legal issues as opposed to having to educate the arbitrators as to the underlying law? Who would like to start? Why don't we start with Friedrich?
Yeah, I'm happy to start with this. I think as a preliminary remark, Jura Novit Curia or Jura Novit Arbiter is not only a principle about the knowledge of the law. I think we have to conceptualize it in a broader way as a principle that allocates responsibility between parties and decision makers when it comes to the process of legally resolving a dispute. The question, I think, Mohammed, you already very well outlined this, is the decision maker strictly bound by what the parties put forward, or can the decision maker render in a way its own independent legal reasoning? Just this as a preliminary remark. Now, of course, the degree to which a decision maker can, independent from what the parties put forward, develop its own legal reasoning, of course, presupposes some knowledge of the law. And here the question comes in, what is the party's expectation? Just based on my own experience, I would make a distinction between domestic arbitration proceedings and international arbitration proceedings. If I have a domestic arbitration seated in Germany, parties from Germany represented by German counsel and a tribunal that is German, then the parties would have the expectation that the tribunal has knowledge of the law. But we all act in international arbitration proceedings, often under a law that is not our law we are trained in. And in this case, I think it is not the party's expectation that the tribunal necessarily knows a foreign domestic law. And that's also why, for instance, I, as an arbitrator, when I sit in a case where a foreign law is applicable, I would give express directions to the parties to brief me on the applicable law precisely because I don't have the knowledge myself as an arbitrator.
Nicola, questions?
Yes, yeah, sure. Happy to react to what Friedrich very well explained. Of course, I would agree with him even from my, let's say, Swiss viewpoint. Let's say I would be in a very similar situation in a purely Swiss arbitration with Swiss parties, Swiss counsel, Swiss arbitrators. Everyone would expect the tribunal not only to know the law, but to apply it, to have a duty to apply it sua sponte, and not be bound by the legal arguments and pleadings made by the parties. When it comes to international arbitration, of course, the challenge is that often parties have different backgrounds, have different procedural traditions, and of course the one that comes to mind more prominently is the divide between, of course, civil law and common law, because as Mohammed was explaining at the beginning, the starting point is very different. And so what is my experience in these kinds of arbitration, where you may have different actors, parties, counsel, arbitrators coming from different procedural tradition and legal backgrounds? One possibility is, of course, for the arbitral tribunal to address the issue squarely at the issue of the applicable law and the responsibility, the allocation of responsibility in ascertaining it at the outset of the arbitration. And so what I've now do in my arbitrations where where I sit as arbitrator is I propose language in I propose a formulation that essentially embodies a notion of Jura Novit Curia at the very outset of the arbitration in the so-called terms of reference, which are the documents that everyone signs at the beginning of an arbitration or equivalent documents. And so I propose a formulation along the following lines, saying that the party shall establish the content of the applicable law. So as Friedrich was saying, of course, the arbitral tribunal welcomes and expects the party to brief the arbitral tribunal, especially when the law is foreign law. But I also specify that it is understood that the tribunal may, but is not required to, make its own inquiries into the content of the applicable law. And so a provision along these lines, I think, at the beginning of the arbitration avoids misunderstandings and also avoid perhaps frustrating the expectations, as you were saying, Jason, at the later stage. And discussing with the parties this kind of rule is I think, best done at the outset, where possible issues on the tribunal's power to introduce legal arguments ex officio or rely on authorities not invoked by the parties have not likely come up yet. As the arbitration goes, the opportunities for disputes on these issues are likely to increase, so it's normally always better to address this at the beginning. I should also say that when you do it at the beginning, parties do not really focus on this issue. They have different things into their minds, so no one really objects to this kind of rule. In my experience now, I've proposed it at least, I think, in more than 10 cases where after I thought about doing this, and I never received any objection for any party to this kind of rule. So it allows, is a means to manage expectation for the parties. But, and this is also important, is also useful if the tribunal needs to, make its own research, needs to rely on a provision, needs to rely on an authority not pleaded by the parties at a later stage because, for instance, the parties have done a bad job, which is always possible, or because you have inexperienced parties that have not really been able to focus on the right issues. So somehow also the Jura Novit Curia is yes an allocation of responsibility rule, but it's also somehow a shield on requests to annul the award based on due process consideration, because the party would allege that it has not been given an opportunity to plead on a certain issue or to discuss a certain legal authority.
Well, maybe we can talk a bit about.
Xian has arrived.
Xian has joined, yes.
Oh, Xian's here. Good.
Very sorry. I'm not sure if I've gotten the time wrong. I've just seen my emails. I'm sorry about this.
No, please. It is not a problem. We were doing fine without you. We're happy that you're here.
Excellent. Thank you. Good
So,
to see everybody.
let me let me ask a question to move the conversation forward, and then Xian, you can jump in as you desire and help us steer the conversation as well. I think that Mikola's comments raised the question of due process concerns for the parties, particularly where the tribunal makes a decision based upon legal arguments that haven't been presented by the parties themselves, and they have not had the opportunity to respond. I'm wondering how seriously that concern actually is in practice, given the extensive back and forth that will usually have taken place. Is it true that parties are sometimes, maybe often, taken by surprise, that they haven't truly had the opportunity to have their arguments fairly heard? Is this a rare occurrence? And then at the annulment or the recognition and enforcement stage, in your experience, how receptive are reviewing courts to arguments that are made along these due process lines? Mohammed, do you want to start?
Sure, gladly. Let me try and take sort of a little bit of a structured approach in my answer. I look and I would submit to you that there is what I call the Jura-Novit Arbiter triangle, where three important principal feature. Party autonomy, which as we know in arbitration is quite overarching. Due process, which Michele and Frederick has referred to, and we will see that across the spectrum of legal systems, due process is an evolving concept, and sometimes dubbed as due process paranoia, because people use it and abuse it in different ways. But we will come to that. And the third element is the proper and correct application of the law. And I think tribunals grapple with these three concepts. And the scenario we have is that a case is pleaded by the parties on its facts and presumably on the law. And Michele is quite right. The early on you address the issues of how the tribunal is going to go about addressing issues of the law in terms of ascertaining the content of the law, the more likely they would charter a proper course during the proceedings in dealing with the parties' expectations there. And the rule of thumb when it comes to parties, especially in international arbitration, is no surprise. No surprise, not in the outcome of the decision, but how do you arrive to that decision-making process? And this is where Jura-Novit Curia lurks there as the devil dealing with that aspect. And how do courts normally deal with that? And I think here we normally address Jura-Novit Curia from the perspective of a civil common law divide. I think that is not an entirely accurate sort of test, because even though Jura-Novit Curia or Jura-Novit Arbiter it originated and evolved from civil law jurisdictions, it is not a one-size-fits-all. Even across civil law jurisdictions, they have different variants of what constitutes Jura-Novit Curia, and so is the case with common law jurisdictions. It suffices even to share with our participants today that one of the very rare occurrences in legislation comes from the English Arbitration Act itself. Section 34(2)G, if my memory does not fail me, is one of the very few laws across the globe that deal with a statement, provides a statement which is basically whether and to what extent tribunals should take the initiative in ascertaining the facts and the law. In some civil law jurisdictions, the idea is the facts are given by the parties. You cannot be surprised on the law. And I think we will have, as we go along with the discussion, and I'm sure Michele will share his excellent thoughts with Frederick as well, about the approach taken by German or Swiss courts. Swiss courts, for example, add a new layer. There are decisions in 2018 and 2019 where it's not sufficient to say that application of a legal provision would come as a surprise to the parties. You have to show the court that it was unforeseen to apply that provision of the law. And that is, for example, the situation under Egyptian law, where courts expect arbitrators to characterize the contract, apply legal provisions, where, even if not necessarily pleaded by the parties as such. Whereas French courts, which is normally presented as the leading legal system when it comes to civil law jurisdictions, take a very firm view in terms of no surprise at all, whether on the facts or on the law, even authorities cited by the parties. So pretty much we have to navigate carefully our way as arbitrators sitting in cases. How are we going to go about to decide the case? And here is an element that is adds a further complexity, or a layer of complexity, which is, would you classify this as a manifestation of the lex arbitrio, or the procedural law? Is Jura-Novit Curia about procedure? So you would follow the law of the seat or the procedural law chosen by the parties? Or is it also a manifestation of a substantive aspect of the law governing the parties' dispute? And to that extent, you should pay attention or take into consideration how the substantive applicable law takes on board Jura-Novit Arbiter or Curia. And I think this is an exercise on conflict of laws, which normally many arbitrators shy away from addressing, but it is indeed very interesting and very important. I would stop here. There are many other thoughts I'm happy to share, but I would stop here and perhaps invite Xian if she wants to add further thoughts. Xian, just so you know, I did a very brief introduction, definitely not as good at the introduction that you would have done, but I think you can certainly share your thoughts there as well.
No, hardly. And thank you very much. And apologies for the confusion in time. I think that certainly Mohammed raises one of the key issues, I think, in relation to your Novit Arbiter and the application of that in the course of international commercial arbitration or investment in arbitration indeed as well. And that is the issue, and as raised by Jason, the question as to due process and the fact that it is an evolving exercise in the course of the process. And may I add to that, I think that the due process aspect is also one of the parties' expectations. And when Mohammed raises the point as to surprise, and then also the question as to investigation, the national legislation and the expectations within each of these national systems are slightly different. And of course, they do come from and originate from the civil law jurisdiction, but in fact, even in the common law jurisdiction, there are certain expectations as to what the parties are to accept, and indeed what the parties have signed up for in the course of international arbitration. Even in, for example, the US courts, and Mohammed has mentioned the English courts, but even in the US courts, there is reference to the New York Convention. The US Ninth Circuit has recently observed that under the New York Convention, when examining whether the award exceeds the scope of an arbitration agreement, it's not whether it's whether the award exceeds the scope of the arbitration agreement, not whether it exceeds the scope of the parties' pleadings. And so there is such distinction as to the full range of the arbitrator's powers. However, when parties in fact appoint arbitrators themselves, in fact, there is a choice being made at that expectation to minimize the surprise element. And so there is also case law where to the extent that parties choose an arbitrator with a certain legal qualification, there is then suddenly a narrowing of surprise element. And so when you have questions as to due process later on, or when due process issues arise in the enforcement element, courts will, and Hong Kong courts and Singapore courts out here in Asia, have taken that into consideration when dealing with or addressing the surprise element.
Friedrich or Mikola, do you have any observations?
If I may, I have one further thought on this due process dimension of Jura Novit Curia. Of course, due process is in a way an umbrella concept that covers various procedural guarantees, and I want to focus on those that Mohammed and Xian mentioned, which are reflected in the New York Convention. And I have two observations in this regard. First, the improper use of Jura Novit Curia may indeed create a ground for refusal of recognition and enforcement. This is because, as my co-panelist rightly said, a tribunal must respect the party's right to be heard. It may not exceed its powers. It may not disrespect the rules of procedure as agreed or as otherwise applicable. Article 5.1 lit B, C, and D, and arguably the public policy dimension. But second, and vice versa, the failure to use the principle Jura Novit Arbiter may, under certain circumstances, also create a ground for refusal of recognition and enforcement. As part of the duty to render an enforceable award that is not refused recognition and enforcement, a tribunal may be obliged to address on its own initiative a mandatory norm whose disrespect may create a ground for refusal of recognition and enforcement because the award would breach public policy. So in the European Union, we have this issue, for example, with certain mandatory norms of antitrust law. In the Eco-Swiss decision, the European Court of Justice ruled that certain norms are part of the European public policy, and if you disrespect them as an arbitrator, you risk rendering an arbitral award that will be refused recognition and enforcement or set aside. So how do you deal with this? As an arbitrator, let's say you have a long-term contract on the delivery of certain goods, whatever, and you are not sure whether it is in line with European mandatory antitrust laws, you might have a duty to bring this to the attention of the parties and to seek briefing on this issue. And the failure to do so might again mean that you breach your duties as an arbitrator. Another scenario, you have an arbitration where one party does not participate. Well, then even as an arbitrator, you might have on your own initiative need to review whether you have jurisdiction or not, whether the subject matter is capable of being resolved by arbitration, because otherwise all of this might be an issue at the post-award stage. So these due process concerns do exist in relation to Jura, Novit, Arbiter, but it is both sides, the improper use as well as the failure to use the principle Jura, Novit, Arbiter, which might create problems for the enforceability of the arbitral award.
Mikola, do you have any observations, especially from the perspective of international, of investment treaty arbitration?
Yeah, sure. Investment treaty arbitration is a bit of a, I would say, a special creature here. Certainly the Jura, Novit, Curia principle applies. We've seen now a number of tribunals that have expressly referred to it in their awards, and also we have had a number of ICSID annulment committees where the ICSID convention was applicable, who have upheld it and rejected set aside applications based on that grounds. And I think there are even stronger reasons to apply Jura, Novit, Arbiter in an investment setting than in a purely contractual setting that you would have in commercial arbitration. And what are these reasons essentially? Well, let me just mention a few. First, in an investment arbitration, normally the applicable law is found in an investment treaty rather than in a contract. And investment treaties, as we know, are similarly drafted, and the legal issues are recurring across cases, even if the applicable treaties are different one from the other, or present certain dissimilarities. And as a consequence of these recurring issues, investor state tribunals also refer to the decisions of prior tribunals in a sort of quasi-precedential system. Tribunals even speak of the duty to pay due consideration to earlier decisions. They even speak of the duty to seek to contribute to the harmonious development of investment law. So what I'm trying to say is there is a certain inclination, certainly much bigger in investment arbitration than in commercial arbitration, to follow consistency in case law. Whether this is appropriate or not, that's another discussion. But certainly there is this kind of inclination. And the third factor, the decisions of investment tribunals themselves heavily impact the development of investment law. Now we even have treaties that specifically react to positions taken by a certain line of jurisprudence, by clarifying the treaties and saying this is not what we understood, what we intended, etc. And tribunals are clearly conscious of this role. Fourth, the awards are generally public, unlike commercial arbitration awards. And importantly, the subject matter of the investment arbitration disputes normally, not always, but normally involves issues of public interest, public interest dimension going into health, environment, etc., which may have an impact on broader constituencies. And so the decision may impact broader constituencies beyond the disputing parties. And this in itself also means greater transparency, greater openness of the system. So what I'm trying to say is this: in this framework, it is, in my view, safe to say that more tribunals feel that they have a duty not only to the disputing parties, but, and here not everyone would accept this, but certainly there is by some at least this view, they have a duty also to the system as a whole. They feel they must have regard to the consequences of their decisions for third parties that are not necessarily represented in the proceedings. They feel they have a duty to engage in a judicial dialogue with other tribunals that have decided similar the disputes based on the same measures or arising out of the same treaty, etc. They feel they have the duty to engage with important scholarly debates and so on and so forth. I think Friedrich has used a very good expression in one of his publications. Investment arbitration is a polycentric model of adjudication, and I entirely agree with that. And an additional point, I think Mohammed made it at the beginning by saying some tribunals view themselves as the guardians of the law, and therefore they have to state the law and apply the law correctly. This is entirely true, and there is a much greater emphasis in investment arbitration on correctness than there is in investment arbitration. There is a greater emphasis on correctness than I would say there is in commercial arbitration. Even in investment arbitration, there's now discussion even to create an appeal mechanism for investor-state awards, which is, of course, is entirely absent in commercial arbitration. So I think for all this reason, I think it's not untenable to argue that the investment arbitration is limited to what the parties plead in terms of the law. And I think there is a very good expression by Jan Paulsson that said that it is he said something like the arbitral tribunal should not content in itself with the less implausible of the parties' argument. I think he said something along this line. And I think I entirely agree with this, with his view.
I'm really struck by, I think those are highly interesting, I think, observations by all of you. I mean, just to pick one thing that I was surprised by, Mohammed's suggestion that that at least in some cases, arbitrators may not be technically permitted to go beyond the citations of the parties, and that strikes me as being I just can't imagine that from my perspective here in the U.S. There's a very famous magazine article by Judge Richard Posner where he says, ironically, what am I, a potted plant? Right. And the basic idea here is that he is not some sort of machine where he takes what he is given by the parties and then outputs through some automated process an opinion. But of course, he's the judge, and that means he is, of course, free to go beyond what the parties have submitted. And so the idea that it might be so completely the opposite, I find quite interesting. And so we might want to explore the extent to which that really is sort of an alternative reality that's out there. But I guess more generally, I was really struck by this idea of the standard of cannot be surprised by the law. And I'm wondering if that's a subjective standard, or I assume it's an objective standard, did not foresee or could not have foreseen that the decision might be based on some law. And if that's the standard, I just wonder, I mean, how could the process fail to give the parties at least the potential of foreseeing the basis for the decision? There must have been a breakdown at some point in the procedure, either the fault of the arbitrators or the fault of the parties, or there are perverse incentives within the system that prevent, again, either the parties or the arbitrators from raising all of the relevant law. So I was wondering if you can talk about that. What is the source of the breakdowns, and do you agree with that characterization? I mean, if we're at the point where the parties truly are either subjectively or objectively surprised, how did we get there? And how can we restructure the system to ensure that we don't get there in the future? Thoughts? That's a big question, I know.
Happy to chime in to try and frame it a little bit for my colleagues. to add their thoughts. So that's a very interesting comment. I mean, we can break it down to many issues, but let me focus on a number of things. First of all, what really happens when tribunals find that there are arguments presented by the parties that do not really address the issues that the tribunal needs to decide on as a matter of law. So, and let me give you real life examples from cases and how courts dealt with it. So in one specific case, for example, in which I personally was sitting as an arbitrator, presided by a Swiss arbitrator, a very famous and very capable Swiss arbitrator, and we had a colleague from England sitting as the third arbitrator in a high-profile case. So the parties pleaded their case under the contract and under the law. The law is the law of a state that subscribes to Jura Novit Curia, though no clear precedence on the limitations thereof. The seat of arbitration chosen by the parties in a jurisdiction that accepts that arbitrators have a fair discretion when it comes to ascertaining the content of the applicable law. So for us, the seat and the governing law, the merits, were more or less aligned on giving us that option. We're also presided by a Swiss president who is very comfortable with Jura Novit Arbiter in Korea, but we have on the tribunal a colleague from England who's not really into that at all. And what happened is the parties pleaded their case, and it came to one specific element where the parties said, well, there is a breach of good faith and a breach of a certain legal right under the law. We had two things. First of all, to ascertain what is meant by good faith and its parameters. And secondly, whether under the law there were certain remedies given. There wasn't much in the submissions on this. And so as a tribunal, we had two members comfortable with that. A third member said we can't and we have to deal with the parties' pleadings and should not go beyond this. And this brings me to a very important limitation across all legal systems. The barrier that you do not cross is that you do not go beyond the parties' claims and relief. You cannot, as a tribunal, order a relief that is not requested by the parties. You cannot, as a tribunal, give quantum that is beyond what is pleaded by the parties. But then it gets really into the gray area, the twilight zone, as to the arguments element or the authorities, because you frame your arguments within the limitations of the claims and the relief sought. But what if the tribunal finds that there are some plausible provisions to support an argument that is not on record as such? And this is what happened in that case. And our proposal to our presiding arbitrator and to the other arbitrator was, instead of us as a tribunal thinking in a sort of majority-minority situation, let us do the following. Let us write to the parties an email asking them whether on the specific issue of that point in dispute, they accept that the tribunal is entitled, not to give us the authority, is entitled to consider whatever legal provisions under the applicable law that may apply to that within the context of the relief sought by the parties. So we framed it in a neutral way so as not to be seen as aiding one party over the other or giving a party insight as to what we're going to decide. And believe it or not, both parties came back and said, no, thank you very much. We don't want the tribunal to apply a provision that is not pleaded by the parties on record, and we want these only within the legal provisions on record, presented as legal authorities, nothing more. So that was a clear answer, and we as a tribunal proceeded accordingly. Now, of course, this has impacted one party's arguments in a way, because you had then to reject the argument, but it was clear that the parties in the dispute had a common vision as to what they considered to be a no surprise. A no surprise to them was basically do not go beyond the case file on legal authorities. And this is pretty much, even though we say France, of course, is a leading civil law jurisdiction, the attitude of French courts is that their view of the idea of due process is that it applies to fact and law. Whereas in Switzerland, for example, in a 2018 judgment by the Swiss Federal Supreme Court, the federal court says the right to be heard mainly relates to ascertaining the facts and not the law per se. However, in fairness to our colleagues in Switzerland, and I will be corrected by Michele if I'm wrong on that, in 2019, in a case relating to a FIFA dispute, which is in the context of football, or because for US colleagues, soccer, in that way, the Swiss Federal Supreme Court said, when applying, of course, you can apply provision that was not invoked by either party, insofar as the applicable law is known and agreed by the parties. But the issue was, what happened is that the tribunal went beyond that and decided ultra petitas, so they exceeded their jurisdiction by awarding damages when the relief requested was only declaratory relief. So this is, again, even on the aspect of a Swiss Federal Supreme Court, which subscribes to a very open approach to Jura Novit Coria or Jura Novit Arbiter, there are limitations. The other case I would share with you before I shut up so that my colleagues can consider this, comes from the common law. Let's consider English courts. So in English courts, and we've heard a few years ago the Chief Justice speaking of arbitration may potentially lead to a contamination of the common law because of failure to follow the precedents. And even though these sort of remarks were retracted later on, but in the Carebox versus Lewis Dreyfus case in 2011, the issue before the court was basically a setting aside because the tribunal failed to follow the English precedent on the matter. And English courts under Section 69 of the English Arbitration Act have the possibility that the party may lodge an appeal on a point of law within certain limitations. Take that and contrast it with Section 68 in a common law jurisdiction talking about a procedural irregularity. And the court in that case, even though said that the tribunal's award is set aside because there was a clear precedent in there and there is an appeal on a point of law, the idea was basically the tribunal should have considered the leading precedents, but the caveat, put it to the parties to comment on it before you decide on this premise. And this is the no surprise element. Now, of course, here tribunals have to walk a very fine line, because when you put an authority on the record, no doubt it may assist one party's case, or it may give insight into how the tribunal may wish to decide. So tribunals have to be very careful when treading that path to ensure that that does not aid a party vis-a-vis another party. These are just a couple of cases. I'm happy to share more cases, of course, from other jurisdictions, but I assume that my colleagues may have other insightful examples to share.
The idea of supplemental briefing and also of courts sort of showing their hand in oral arguments is so part of the process in US litigation, right? And so I think you're presenting a very different set of considerations and worries that are really quite foreign to our domestic litigation system. But let me stop and invite the rest of you to comment on Mohammed's provocative intervention.
Well, I'm happy to chime in here, and certainly building on Mohammed's point, and actually quite practical points about raising these issues and the framework of the legal understanding of the tribunal when the parties have not addressed this point is one way to minimize that breakdown that you raise in your question. From a practical perspective and from what happens in practice kind of expectations, the parties themselves and the way in which they present their case, oftentimes in civil law jurisdictions, you will see a lot of data dumping or factual dumping of the case before the tribunal, with the expectation, in fact, that the tribunal does know the law. And that's, of course, drawn from the litigation aspect and their experience. So depending on how much experience they have in international arbitration, there may be differing expectations as to what the tribunal actually knows in the first instance in terms of the law. And so with regard to where the parties stand at the outset, again, drawing back on my initial comments on parties' own expectations, parties themselves may initially be presenting a very factual heavy argument during the course of their entire proceedings and their submissions as well, leaving the arbitrators and the tribunal to be in a position where they are expected to know the law. And so the proactive aspect and responsibility of a tribunal in doing so in the way that Mohammed has exemplified is one that could be the cause of breakdown if the tribunal is not appropriately alive to the issue that they bear this responsibility. And oftentimes what you'll see is that you will have engagement, but not necessarily the framework of, not oftentimes, but there are times where you will see not necessarily the legal framework of the pleadings being carried out, but rather a very factually based set of pleadings. And where you might have the breakdown is in fact in basic timing of how the tribunal engages with the file. There may be times, and this is certainly at the institution, I would have seen this, there may be times where the tribunal is not necessarily as engaged as it should or could be during the life of the proceedings, and only after the proceedings have closed are they then tucking to the file because they're drafting the award, and suddenly these issues arise as to legal questions or even factual questions, but more importantly for the purposes of this discussion, legal questions that have arisen that can no longer be presented to the parties. And so how do you build a file and a legal framework around your award when you are limited in access to the law that you are supposed to be applying to the factual matrix? This is also where institutions can play a meaningful role. And in that regard, the scrutiny of the award process is something that I think is quite important to as a responsibility of the institution to ensure or enhance or ensure an enforceable award. And to that regard, there are times certainly in the scrutiny process where there will be a review as to the footnotes or an assurance as to, well, this claim has been made in the body of the award, hasn't been footnoted, has this legal proposition in the body of the award been dealt with by the parties? And this is the point where the tribunal will have to reckon with the question as to whether there has been a surprise element in the body of the award that hasn't been dealt with from that the parties haven't had an opportunity to address, or that is not on record and may lead to a less enforceable award. And so the scrutiny process can play a meaningful role in this regard and catch these moments. But certainly I think that part of it is fundamentally when the question as to breakdown comes in, part of it does come into timing of the engagement of the tribunal with the file itself.
Friedrich, could I invite you for comments?
Thank you. I very much agree with what Can and Mohammed said on this topic. Let me just maybe bring in a German particularity or a practice that is sometimes practiced in particular in domestic arbitrations, and that is there is quite a commitment for early settlement, amicable settlement during arbitrations in Germany. You will find this in the rules, for instance, of the German Institution of Arbitration. And so what tribunals sometimes do is that they schedule an early meeting with the parties after, let's say, one round of written submissions. And then if both parties request this, and maybe declare also waivers, the tribunal would open its mind and give a preliminary legal assessment of the case, hoping that the parties on this basis can either settle the dispute or at least narrow it down and then focus on what's really relevant and the remainder of the proceedings. And this sometimes works out very well. Sometimes the parties just settle and it's perfect. You have been very efficient. Everything is done quickly. But sometimes it does not work out. And the case continues over years and years and years. If it's, let's say, a big construction dispute whatsoever, where the case is big. And then it may be that the tribunal, at the time it renders its award, somehow sees the case entirely different and deviates from a position it has previously articulated to the parties in a preliminary legal assessment. And that's one of the circumstances where German courts have set aside arbitral awards and have said, well, if you have once given your views to the parties and the parties rely upon this, and you then later deviate from this, that might be surprising. That's a breach of the right to be heard. So that would be, in a way, an error of the tribunal. The tribunal should have done what Mohammed and Can outlined, to bring it to the attention of the parties that they maybe need to brief an additional point, or that the tribunal changed its preliminary views. That is a risk, a situation where we have such breaches of the right to be heard, surprising decisions, and this may then be a pitfall at the post-award stage.
Mikola.
Yeah, very interesting. And just to add my 2 cents on especially some of the comments that Mohammed made, I completely agree with him that somehow the outer limits are always the petita, the relief sought by the parties. Of course, the tribunal cannot go beyond what is claimed, cannot go beyond the claims, it cannot award a different relief, etc. But there are then certain gray areas which are very difficult to give precise answers to. What about interpreting or completing the relief sought by the parties, not changing it, but perhaps interpreting and completing? That's perhaps more controversial. For instance, if a party simply requests interest without either specifying the rate or the modality of payment, and then the tribunal decides to award compound interest, is that something that is permissible within the boundaries of Jura, Novit, Curia, or not? This was precisely the case in an investment arbitration involving Egypt, the Vienna versus Egypt arbitration, where the tribunal decided to do exactly that. And then the case went before the annulment committee, and the annulment committee endorsed the approach. It's saying that the matter of appropriate interest had been somehow discussed in the proceedings, and that both parties must have been aware of the possibility that the tribunal would order compound interest at an appropriate rate in accordance with international practice. In other words, even if it didn't say it in so many terms, it applied the foreseeability test that Mohammed was mentioning before. What about if again, speaking of gray areas, what about if the tribunal reaches the same result as requested by a party, and so it technically awards the same relief, but requalifies the grounds, for instance, reaches the same result but through a different legal ground? It reaches the conclusion that the contract is null and void, but for a different reason than the one alleged by the parties. Is that permissible or not? Are we here speaking of Jura, Novit, Curia or not? Jurisdiction, thinking for instance of the ICSID framework, where even the convention says that the tribunal can or must, and I would have to check now exactly the language, but check jurisdiction, review jurisdiction sua sponte. Now, is it allowed to decline jurisdiction in a case where the respondent has objected to jurisdiction, but it does so on a different jurisdictional ground than the one alleged by the party? So I think these are very difficult questions. I don't have the answer to those, but it's likely that it is these gray areas that will most likely cause trouble.
Can I add two further examples? I'm just tempted because I fully agree with Michele there. And I think it is deserving for our participants to see that. There is also the catch-all relief that you normally see feature as a boilerplate, which says, or any other relief that the tribunal deems appropriate. And this then lends itself to a question whether this is a catch-all whereby that gives the tribunal the discretion to proceed in a certain way. And that goes back to Michele's point, is that there is no uniform answer, but tribunals normally are very, let's say, vigilant or prudent in exercising discretion, because otherwise the sky would be the limit. And then the other example I would give in that sense is basically, and that can happen, and I've seen it in a number of cases, a party pleads a case on the basis of, let's say, abuse of right for jurisdictions that recognize the concept of abuse of right. So you say that is a breach of my right and that has been abusive under the applicable law. Point, nothing further in the submissions, no provision, no authorities, nothing. Does that give the tribunal then the authority? This is a matter, it is on record, it is pleaded, but you don't have sufficient, let's say, substantiation of that. Would you dismiss it for lack of seriousness or lack of substantiation? Or would you, as a tribunal, engage with the parties and start asking questions about provisions in the law about abuse of right and what criteria of abuse, disproportionality, pursuing an illicit interest, or something that is beyond what is customary acceptable? These are all questions that tribunals differ in their approaches when they deal with them. And when we talk about diversity, it becomes all the more difficult when you have arbitrators of different backgrounds. Arbitrators even who are more accustomed to sit in domestic cases, but not international cases. And so when they sit in an international case, they try to bring the baggage of domestic perceptions and dealing with these questions to an international context. So I think these are all very valid questions. And I think the bottom line, basically, when it comes to that, is that transparency and early engagement about what the tribunal is expected to do if these questions arise is pertinent.
May I just add one point to Mohammed's point, and that is the catch-all point. And coupled with that, I think you'll regularly see, if not almost as a matter of course in an arbitration award, the provision in the award that says the tribunal has reviewed the file. You can trust the tribunal that has reviewed the file and considered all factors in the file, but this is what we say. And so anything we've left out is something we've considered, so don't worry. And whether you can trust that, and also whether you can trust the last word in the award that says that all other claims and reliefs have been dealt with or dismissed, is something that, again, is the framework and the insurance that the tribunal has implemented in the body of the award, but may not necessarily have been tested properly. And so the reality as to what the parties are expecting of the tribunal with its variety of makeup, whether they are from civil law, common law background, or whether they are a professor in that particular legal tradition, as was seen in a recent case in Brazil, where Sir Bernard Ricks had to deal with an enforcement issue in an arbitration award, where one of the comments that he made was, in fact, the fact that the tribunal itself was comprised of 2 Brazilian professors gave a certain expectation as to the trust in which, regardless of whether all aspects of the Brazilian law were dealt with or were set out in the award, is not as much of a concern, because the parties had created that framework by choosing the arbitrators that they had chosen. In any event, I think the point is that you're creating certain insurance, you build in insurances in the body of the award to and also in the makeup of the tribunal to make sure that you don't have surprises.
Sheehan, your comment was really interesting because it illustrated, I think, what is bothering is the wrong word, but it's sort of like kind of going on in the back of my head as I listen to you talk, and I'm trying to sort of characterize or rephrase, translate the issues you're talking about into sort of vocabulary that I'm familiar with from my own research. And to me, the problem, it just seems like that what we're talking about really is sort of the standard of exposition or of reasoning of the tribunals. Are they expected to engage in a certain level with the arguments the parties have made, which is really in a way kind of like the inverse of the main problem that we're talking about now, which is dealing with providing reasoning that the parties themselves haven't suggested in the by making legal arguments. But the flip of that is not engaging at all with the arguments that the parties have really made in the way that you've suggested, right? Everything else in the file, trust us, we thought about it, but it's no good. And so I guess I'm wondering, at the end of the day, are we really sort of just wrestling with sort of like the standard of exposition of reasoning that we expect from tribunals more than we're sort of worried about what actually influenced their decisions, which is often, or not often, but can actually not track very well how they explain how they got to a particular position. Does that make sense?
If I may comment on this point, I think we're talking here about various dimensions of the right to be heard. The right to be heard, which is, as we all know, reflected in Article 5.1b of the New York Convention and also part of public policy, is a fundamental participatory right of the parties. And it details first that a party can put forth its case and the relevant evidence. Second, it can comment on what the other side puts forth. Third, if the tribunal makes any independent investigations or comes up with a legal provision the parties did not reasonably expect, the parties must have a right to comment on this. And then fourthly, as a flip side of all of this, it entails that the tribunal has a duty to, I use now the terminology used by German courts, to consider and take into account what the parties have put forward. And now here we are indeed at the flip side of everything, what Chan just said, which goes to the question, well, it's not enough to give the parties the right to comment on things. You must also engage with this as an arbitral tribunal and take this into account. Now, this leads to a follow-up question, which is, well, how can courts review this at the post-award stage? Because we all know there is one fundamental principle of arbitration and of review by courts at the post-award stage, which is we don't review the merits of it. So we cannot come as a court and say, well, that tribunal, you made a mistake because the argument A was put forward and you should have somehow addressed it in a different way that would have been much more logical and better. And I think the approach we see in case law, and we've just done a big study on due process, is that courts are very hesitant to come to the conclusion that a tribunal failed to consider and take into account the parties' arguments and pleadings, precisely because there is this prohibition of a review on the merits. Only if you can really see that it is only artificial reasoning by the tribunal and that it disregarded entire relevant arguments that are relevant based on the tribunal's own reasoning. That's not something the court can review. Only then, exceptionally, courts have found that the right to be heard has been breached. But this dimension of the right to be heard exists, and it is relevant. And I know there is this practice of tribunals to write, well, we've considered everything the parties have put forward. I actually do it myself. That's probably not enough to comply with this duty to just add this sentence, but it is quite a high standard that must be overcome to successfully challenge an award for the failure to engage with the parties' pleadings.
So I noticed a few minutes ago that we have Professor Simeonides on the as a participant, and I was going to give him a standing invitation to intervene, given his expertise on this and various issues. And at just that moment, he raised his hand to ask a question. And so I think that is fortuitous. And so if it's okay with the panelists, I would like to invite him to enter the conversation.
Well, thank you very much, Jason. And by the way, congratulations for bringing together this outstanding panel. I am totally intimidated by the depth of knowledge and expertise, especially because, unlike all of you, I'm a total stranger to arbitration matters. I know very little. But the little do I know that I know raises a question that I think Professor Rosenfeld just touched on it a moment ago, which is when I raised my hand. And that is the fact that there is very limited judicial review of arbitration awards on matters of law. I mean, if it's an international award, it's limited by the New York Convention. If it's domestic US arbitration, it's probably even worse because we have this standard of manifest disregard of law, which is a very high threshold. Now, I don't know about the laws of other countries on this precise question, but it seems to me that there must be an interconnection between the extent to which a legal system allows judicial review of awards for legal matters and the subject that you are talking about today. Frankly, I don't know which way it cuts, but I think there must be a connection. And I wonder if you can enlighten us on that. And by the way, my question, I should reiterate, is one of ignorance, not one of knowledge. But as a teacher, I get this all the time from my students. So I sit here as a student rather than anything else. But thank you again. Congratulations, an outstanding panel.
Thank you very much, Professor Simeonides. And I think in fairness, even though he humbly and modestly said his familiarity with arbitration is not much, he's a world-leading authority on private international law, hence the question, of course. And if I am were to chime in, and my colleagues can, of course, share their thoughts, 2 points come to mind there in response to that question. The connection or the interconnection or the rapport that we would like to make in terms of whatever is going to happen with the award and how the courts deal with issues of legal questions comes in a package of two. One would be the legal system subscribing to what people, which exists, and it's not something frequent or common, an appeal on a point of law. So even though appeal is not possible, but on a point of law, as is the case under the English Arbitration Act, within the certain limitations of that provision, because it's very exceptional in a way, and the parties are entitled, by the way, to opt out of it, then that is one possible avenue. The other, of course, which has been hinted to by Frederic, Shannon, Michele, is basically when the principle in question is elevated to a level of a public policy principle. And this then applies across all jurisdictions, with differences as to what constitutes a principle of public policy. And I'm afraid that's one escape clause that everyone is concerned about, because states have varying approaches. Even though we talk about domestic public policy, international public policy, truly international, the bottom line in practice is that courts construe principles of public policy in accordance with what they deem to be aligned with their law. And this is the interesting element. Michele has touched upon interest. Interest as a matter of principle is still considered by the laws of the MENA region, including Egypt, as a matter of public policy. I had written and said it is not, because we accept we accept interest in practice. The central bank allows banks to use interest. The one exception to that is the Kingdom of Saudi Arabia, where they do not deal with interest, so it is not recognized or accepted under the legal system. So at best, it could be dealt with as a domestic mandatory rule, or let's say in a domestic context, but it is not a principle of public policy. Yet, courts consider it a principle of public policy. So the two approaches would be either you have an appeal on a point of law or deal with it as a matter of public policy. But in both instances, courts are very aware globally that if they were to annul or refuse enforcement on award on public policy grounds, the next day they will be on the Global Arbitration Review, on directories saying, look what national courts have done, anti-arbitration, not arbitration friendly. So courts are beginning to be more or less, let's say, not necessarily concerned, but they rethink twice before they apply that concept of public policy. Let me give you a very recent example. We had an award in relation to Kharafi, which is a Kuwaiti company under the Arab Investment Treaty, rendered against the state of Libya for about $936 million. That case went 3 times to the Egyptian Court of Appeal, the Cairo Court of Appeal, and 3 times to the Court of Cassation. The final time at the Court of Appeal in 2020, the court said what the tribunal did in awarding these damages was against public policy because the measure of damages went beyond the harm sustained, and it is a principle of public policy to apply damages in a proportionate way. Many people would see that as a trespass on the merits, and that's precisely what the Cairo Court of Cassation, Cour de Cassation, said. Well, that is the position of the Court of Appeal, but with all due respect, you have now looked into the merits, and even if the tribunal has erred on the quantum, it is not a license for the court to rethink or reconsider the measure of damages to that extent. So you can have it the heads and tail of the same coin. If you apply the principle that proportionality is a principle of public policy, well, there is at least merit to what the Court of Appeal said. But if you apply the principle that you do not cross the line and look into the merits and then the quantum, then the Court of Cassation is right. So that's the difficulty with these types of principles, is that you have to look at it from a certain perspective, and the perspective would be defining as to how the court will approach the question. I don't know if Shan or Frederic or Michele want to add something in response to the excellent point made by Professor Simonides, but this was just my thought.
Yes, Professor Rove, Friedrich, please.
Go ahead, please. Sorry.
No, I was just going to add to the dialogue the point of the Article 18 of the Institutional Model Law, which is the opportunity to present its case. And obviously that aligns with the public policy aspect in the New York Convention. And different states have taken a slightly different approach, or most of them will adopt wholesale the Institutional Model Law, Article 18, which states that the parties have a full opportunity to present its case. And this issue is in fact one that I think is left for interpretation, obviously, by the courts, but this is where the variance happens, because obviously the language says full, but in fact, not so obviously, it means reasonable. And so the way in which courts interpret that very clear language that is fulsome in its language, but actually much more nuanced in its approach, is one that I think many courts have grappled with. And in fact, the Singapore courts have recently dealt with this in a quite robust sort of way, where even though the legislation says full opportunity to present its case, it has now clarified from the court's perspective as to what that actually means, and has laid out the due process expectations within Singapore as to what the parties have a right to expect in the course of an arbitral proceeding. And this is where it, again, ties into the public policy aspect of it, is because parties do have an opportunity to present its case, but how broad that opportunity is and how fulsome that opportunity is sets this fundamental stage in the arbitral proceedings itself.
I think if we take a step back and look at the problem, we see that dispute resolution is sometimes not purely based on what the parties put forward. A very extreme approach of such a party-centric approach to dispute resolution would be baseball arbitration, where you have submissions from two parties and you pick, in a way, the one that is the more convincing claim, whatever, irrespective of whether it is objectively correct or not. And at the other side of the spectrum, we would have, Michele already mentioned this in the context of investment arbitration, a polycentric paradigm of dispute resolution, where the decision maker also wants to uphold normative expectations, maybe enforce certain mandatory norms, and so on. And this leads the dispute resolution body, be it a court, be it an arbitral tribunal, to consider legal arguments or make legal considerations that go beyond what was put forth by the parties. Now that's the spectrum in which we are. If we now look at this from a post-award perspective, Mohammed is absolutely correct that we have some legal systems allowing for a limited review of the merits. You mentioned the example of the English arbitration law, in which parties may opt out, but the common approach, and at least the approach under the New York Convention, when we talk about international enforcement of these awards, is that we do not have a review of the merits. That's, in a way, something that is sacrosanct. The parties have expressed their wish to delegate the adjudicatory authority to a private decision-making body, to an arbitral tribunal. So that as such is not subject to review. But of course, the modalities of how the tribunal reaches its conclusion, its award, are subject to a very limited review. One ground for refusal of recognition and enforcement being the refusal of to respect the right to be heard, going beyond the relief requested by the parties, maybe breaching public policy, as Mohammed mentioned. And if we now look at these grounds, we have again, and Professor Simeonidis, you will be happy to hear this, we have a private international law question, which is, well, which law and which standard do we look at now? And under an instrument like the New York Convention, the argument could be made that, well, we have autonomous standards. The right to be heard, that's a treaty. We should not apply domestic law as to what is the right to be heard, but we should interpret this autonomously and come up with an international notion of what the right to be heard means. But many courts have applied the New York Convention and have said, well, in interpreting Article 5.1b, we apply the forum standards. That's the approach you will find in US case law. That's an approach you will find by Austrian courts, by German courts, and so on. Now, whether this is right or not, one may have an argument on this, in particular when it comes to Article 5.1b. In the public policy concept, it's clear, but under 5.1b of the New York Convention, I think one may very well have an argument as to whether it would be better to apply an autonomous standard of this provision. But let's assume it is a domestic law. Well, then you have, of course, distinctions. You have US courts that say, well, right to be heard means that a party has a meaningful opportunity to give its view at a meaningful time in the proceedings. And you may have a German court that seeks guidance from the constitutional notion of what the right to be heard means in Germany. And you might have a French court with a different notion. And here we see that despite a common international framework, suddenly we have domestic law coming in and private international law questions. And this leads to a state where we all talk about Jura Novit Curia or Jura Novit Arbiter and its limitations. But of course, these limitations may apply slightly different, in a slightly different way across jurisdictions. And I think that's, in a way, at the heart of the problem we are discussing today.
Mikaela, can I invite you to offer any thoughts from your world of investment treaty arbitration?
Yeah, Professor Manida's question also triggered some thoughts on this when he asked about the limitations to review the correctness of the legal interpretation made by an arbitral tribunal. And of course, this kind of discussion pops up every now and then also in the investment treaty field. Of course, the mandate of at least if we talk about ICSID, non-ICSID would be regulated exactly like commercial arbitration, and so we would have to analyze the law of the seat that applies in each non-ICSID case. But if we take the ICSID convention cases, of course, the mandate of ICSID annulment committee also does not extend to the review of the merits of the award and the review of the legal interpretations made by the arbitral tribunals. That said, parties have tried and try all the time, nevertheless, to argue essentially that a tribunal got it wrong. And we know from past cases that the grounds of annulments were expanded by some annulment committees to include some sort of review of the merits. We think of the so-called failure to apply the proper law, which is not in itself a ground of annulment, but was kind of subsumed within the broader excess of jurisdiction ground, manifest excess of jurisdiction ground, or even the failure to state reasons. These are all grounds that are very difficult to understand in their exact scope, and then therefore lend themselves well to parties that want to abuse, let's say, of the annulment limited review, the limited type of review that is available at annulment. And so if we think, for instance, of some of the Argentine cases, the paradox that we had there is that the annulment committee concluded that the arbitral tribunal had made manifest errors of law, but of course, mindful of its own limitation, declined to annul the award. And so this is a discussion that, as I was saying, always comes up every now and then, and is again at the forefront of the discussions now, when certain states think that these kind of limitations for investment arbitration, for the reasons that I've stated at the beginning, which is the public disputes, etc., involving potentially third parties, etc., these kind of limitations on the review are not appropriate, and therefore the system should move to some sort of appellate type review that we have for instance, in domestic law.
Mohammed had a quick intervention before we go to Alyssa's question.
Yes, just a quick one. In all what has been written on Jura Novit Arbiter Curia, one thing that came to my mind from the discussion, hearing Frederick and Shannon and Michele, and basically is that we tend to conflate, or I'd say different jurisdictions tend to conflate the right to be heard with inducing a party to put forward a good case. And that is a major concern, because one thing is to hear what the party has to say, and that could be nonsense. And the other thing is for the tribunal to step in, up the game of that party, to induce that party to put forward arguments that that party may not have considered, which could be decisive. And I think these two issues have to be separated. I haven't seen, and perhaps I should hopefully write on that soon, but I haven't seen people sort of separating those issues. It tends to be one overarching principle, right to be heard, and then under that you deal with the various issues. And that ties in with another philosophical question about the duty of the arbitrators. Is it the duty that you render justice in whatever form or shape you think that appropriate, or is it your duty to determine the case in a just and fair manner based on the arguments and the evidence on record? And I say that because normally when people start judging arbitral awards, when they are out and reading them, they are not, well, they have not been briefed enough about the whole background of the proceedings and what the parties' submissions were like. You're judging the arbitrators on the basis of the final product that, and they may have had to go through hell to be able to render that award. So again, judging the award requires understanding, consideration of all what has been submitted all throughout.
I couldn't agree more with Mohammed on this point, and I love his reframing of the question as one of the duty of arbitrators. And it's one of the few notes, you can't see it, but it's on my pad, and I meant to steer the direction precisely in that direction, Mohammed. Alyssa, please unmute and join the conversation.
Sure. So this is a slightly different question, but hopefully I won't take us too far afield. And this is mainly an investment-oriented question. So I was just wondering about the Court of Justice for the European Union seems to be a little sensitive about tribunals doing their own interpretation of EU law. We see that both in Acmea and in some of the sort of confusing lines about not impugning EU public policy in the CETA decision. And so I was just wondering whether that has affected tribunals' behavior at all, you know, in things like energy charter cases, or whether it's just sort of a non-issue because you're never going to get reviewed by them.
Any volunteers to respond to Alyssa's interesting question? No volunteers.
I'm happy just to break the ice, but again, I invite Michele to share the thoughts, but in a very candid and straightforward thing. I think it's investment arbitration being under scrutiny, and some people even use the word crisis to refer to that. I think investment tribunals are increasingly and more careful, for lack of a better term, careful in dealing with matters. They know awards will be made public, but being careful is one thing, and not being decisive is another thing. I think everyone should be careful, of course, when dealing with issues. At the end of the day, there are stakes, whether high or low. But I think nowadays, investment tribunals are increasingly looking more carefully into texts, seeing the submissions, reviewing them, of course, and trying to achieve the optimal sort of resolution of the dispute in light of the cases, the positive cases put forward by the parties and the defenses on record. So I think that indeed, I can't say there is a direct causation in relation to Acmea per se, but there is indeed an interesting correlation of sorts in how tribunals now deal with that. But of course, Michele, Sian, and Frederic, if you have additional thoughts.
Yeah, no, I completely agree. The intra-EU Acmea relationship between EU law, international law, and arbitration, etc., is a very, very complex issue. So I would not dare to kind of give any final thoughts in this few minutes. But you are certainly right when you said the Court of Justice of the European Union does not like investment tribunal to apply EU law, because it considers essentially that the court itself has the monopoly over the ultimate application of EU law. One of the criticism which is made to this kind of approach is why investor-state tribunals should not be allowed to apply EU law, whereas, for instance, daily in commercial arbitration, arbitrators apply EU. So this is not entirely clear why the two situations should be treated differently. The court in Acmea has tried to distinguish the two situations, saying that one, commercial arbitration is based on the will of the parties, whereas investor-state arbitration is not. But this is not entirely convincing because, of course, even in investor-state arbitration, you have the element of consent, as we know well. So there is this issue, and of course, investor-state tribunals are very careful in applying the law, including EU law, which can be part of the applicable law, either if you consider it as international law, because, for instance, it derives from the EU treaties, which are treaties. So it can be international law. It can, of course, also be considered domestic law, although a very specific one. So it's a very complex matter on which I think also the court is still developing its jurisprudence. It is not entirely clear, for instance, how it stands in Acmea and most recently in Comstroy, which is the one that dealt with the Energy Charter Treaty, which I think you alluded to, is compatible, or if it is entirely compatible or reconcilable, with its opinion on the compatibility of the CETA with EU law, where the court adopted a completely different approach, and there the court said essentially saved the CETA dispute settlement a mechanism that's envisaged under the treaty, essentially because it said the tribunal there will only apply EU law, will only apply international law, it will only apply the CETA itself, whereas EU law will be essentially a matter of fact and therefore will escape the application under the heading law. But again, everything is much in flux in this field.
So we have about 8 minutes left, and I've been instructed not to go over, and so we're getting close to the end of our time. I thought I should probably invite Sheann as our convener, if I don't want to put you on the spot, Sheann, but I think I would love to have thoughts from you on the conversation to date, or if you have any questions that we haven't discussed, if you wanted to ask the panelists any last questions.
Thank you very much. And certainly, I think that I think the natural evolution of this conversation today has been fascinating. And I think, I think that we all have many comments to kind of piggyback off of each other that are based off of our framework and understanding as to this concept, but more broadly as to the fundamentals of international arbitration, both in the investment and in the commercial context. What I do think is particularly interesting in terms of the cross-fertilization of these two, of investment arbitration and commercial arbitration, is something that I've long thought this particular topic is ripe for discussion, and the expectations of parties as to the process they have signed up for. What drew my attention earlier in the comments was in relation to the precedential value of case law, that Michele had mentioned in investment arbitration, and the expectations of parties and of tribunals themselves as to reference back to prior case law to inform them for the case at hand. In commercial arbitration, of course, we haven't seen that, but now we're starting to see some principles like that creep into the international commercial arbitration context with the recent publication of the awards concept, and certain institutions have dealt with this, and now more robustly the ICC has as well, and whether this will start to raise expectations of parties and the duty of arbitrators, on the other hand, to to have a greater expectation as to what the law is at hand. And I'm not talking necessarily simply about the substantive law. Of course, this is where I think the Novit Arbiter or Novit Courier concept came from, but rather procedural law. The procedural law aspect of things is where I think there is much more room for expectation raising, I guess. And I'd be curious to hear from my co-panelists and indeed other audience members as to where you see the direction of this aspect going in the context of, you know, the arbitrator knowing the law and what it should know about in the context of procedural law.
The floor is open. Oh, Friedrich, I'll call on you.
Yeah, thank you. I think when it comes to procedural law, we know that typically arbitration laws are not as elaborate as the codes of procedure that we know from court proceedings. If I look, for example, at the code of procedure in Germany, we have, I don't know, more than 1,000 provisions for court proceedings, and then we have a very brief code of arbitration law, which is based on the ancestral model law, and we have a considerable degree of harmonization in the arbitration laws, in the procedural laws, and these arbitration laws then give discretion to the parties to agree on arbitration rules, and that's, to begin with, the tool set that the arbitrators would work with. So they have that discretion to conduct the proceedings as they deem appropriate within the limitations by the rules agreed upon by the parties, typically the arbitration rules. And then we have mandatory norms. And I think here, when it comes to mandatory norms of procedure, issues can arise and problems can arise because the tribunal might not be familiar with all relevant mandatory norms of procedure and their interpretation. And the question then, of course, is also, well, which rules do we have, or norms do we have to apply? Probably those of the seat, because that's where the courts might annul the arbitral award, but potentially also other laws, because the award might be enforced internationally. And I think here we have issues also and problems of ascertaining the procedural law. And I'm very sure that problems may arise in this respect in arbitration proceedings. And in that respect, Jura Novit Courier is certainly not only limited to substantive law, but may also raise questions of ascertaining the procedural law. And leaving that aside, as I mentioned before, the procedural law sets limits to the independent ascertainment of the substantive law. That's the other dimension that is relevant.
Professor Simeonides, excuse me, it's been a long day. We had a rule of seniority at the very beginning of the panel, and so I'd like to honor it by inviting you to close the panel with a brief comment or two, if you have any.
Well, I appreciate the opportunity, but given my ignorance of the law of arbitration, I should hesitate to say anything, except to say that I really enjoyed this. I mean, even at my age, I can still learn things, thankfully. So just a big thanks, and I was just writing to you, Jason, for bringing this panel together. And congratulations and thanks to all the panelists. I would not venture to go into the substance, but just to express my personal thanks to you all for participating in this and giving people like me the opportunity to learn. So thank you.
I think that's a wonderful. I think that's a wonderful way to end the panel. Thank you, everyone, and please enjoy the rest of the conference. And I hope to see all of you sometime, somewhere in the world soon. And I will buy you a beer and thanks for your, or a glass of wine for your participation in this year's meeting. Thank you very much.
Thank you. It's been a pleasure.
Thank you
Bye-bye.
very much. Bye-bye.